people who want to submit questions. If you wish not to have your name as the questioner, as it were, then please put an anonymous question. There's no problem with that. What we do have is a system whereby we have something very special, which George Scanlon, our clerk, has sorted out, whereby it actually tallies votes of popular questions. So we're going to actually see if we can get the top of the charts questions to deal with at the end. I'm going to be dealing with those in terms of allocating them. I get the great job of actually having to allocate the questions. So any difficult ones I can pass on to others, and that always makes me look better. So that's always a good thing. We're dealing with a number of things today. We are very fortunate to have a number of panelists. I'll go through them and introduce them all in a moment. As I say, it's the first in the series of 36 commercial cyber webinar series. This is on cyber risks, ransomware, fraudulent funds transfer, and cyber insurance. And I'm delighted, so I already know that we've got listeners, as it were, and viewers as far afield as Australia for this. So a very warm welcome to our international attendees as well as all of our domestic attendees. As I say, I'm Dean Armstrong QC. I'm Joint Head of Chambers at 36 Group. I'm in the 36 commercial team and head of the cyber team. For a number of years now, I've been involved in all matters data and cyber. I wrote the first legal textbook in the UK on cybersecurity law and practice. That's now got into a second edition. I've also written.
Okay, I think we have a slight problem with Dean. He's gone. He's frozen. So
can't be.
He's back.
Did you lose me?
Yes, but you are back now, Dean. You're back now.
Okay, yeah. Thank you. Along with Fergus McCombie and Kerry Davis, I published Principles of Cyber Litigation, and with Sharm, who's on our panel, I published, it's about to be forthcoming actually, a cyber risks and insurance book. So I hope we're not having issues with the audio. I hope everyone can now hear me. As I say, I don't know quite what happened there, but anyway, that's me. Also, we have on our panel Celso Azevedo, who I'm sure I didn't pronounce correctly there. He's a barrister at 36 Commercial. He's a New York attorney. He is a fellow of the Chartered Institutes of Arbitrators. He has a high-level international commercial practice. He specializes in reassurance, cyber insurance, cyber security, data breach, cryptocurrency, fraud, asset tracing and business interruption insurance law, as well as regulatory investigations, which comprise both advisory and contentious work. His publications include Cyber Risks Insurance, and that's the first edition through Sweet and Maxwell, Walmsley on Business Interruption Insurance, it's a second edition, a chapter on international arbitration insurance and reinsurance and international commercial arbitration practices. As I say, he is a valued and esteemed member of our team, and we welcome Celso, and you'll be hearing a lot from him later. We also welcome, as part of this team, Kerry Davis. She's a barrister at 36 Commercial. She is an attorney and counselor of law in New York in the USA. She specialized in cyber data and technology matters and commercial crime and regulation. She has specific experience of advising on fraud and regulatory matters associated with initial coin offerings and crypto asset transactions, and has a deep understanding of all data protection matters, including the GDPR and the PECR. Kerry is the co-author with me of the book of the Cyber Litigation, the Legal Principles. She also was a huge help to me with the second edition of Cybersecurity Law and Practice and Cyber Risks and Insurance. Sharm Thakrar, he's also a barrister at 36 Commercial. He specializes in commercial litigation and is developing a strong cyber law practice, including dealing with crypto fraud. He undertakes data protection work, advising on issues such as misuse of private information and breach of confidence. And he also is a co-author with me on Cyber Risks and Insurance, a book which is about to be published. He contributed and assisted me with the blockchain and cryptocurrency book as well. So warm welcome to all the panelists. I hope now that my audio is back and in full flow. We're going to deal with the topics today in 4 sections, as it were. The first one is going to be dealt with, I'm going to start speaking about it and then I'll be assisted by Shyam. That's on COVID-19 cybersecurity trends, ransomware, remote desktop protocol attacks, and phishing. What we're aiming to do, the best laid plans, as they say, but what we're aiming to do is to do these 4 sections in about 10 or 11 minutes each, as it were, for each section, which will allow us 15, 20 minutes or so for questions. So we hope to give you enough time for questions. Can I say, for those of you who might wish to scribble down, if we make reference to articles and cases, that what you will receive after this webinar is a very helpful page, which deals with not only the references to the cases, but also a digest of each of the cases we refer to, and also links to each of the articles and extraneous material that we refer to. So obviously up to you if you want to scribble notes down, but you will get the details of the cases, you will get links to the articles. And so I'm going to start actually by talking about ransomware. The Acronis report in 2020 pitched ransomware as the #1 threat when it comes to cybersecurity. In the first half of 2020, 41% of cyber insurance claims were related to ransomware attacks. The threat obviously is increasing all the time, and as you will be aware, the level of sophistication increases with each day that goes by. There are now dedicated pages for data leaks, which basically detail where vulnerable websites, vulnerable passwords, things of that nature are listed on a site which can be bought. And clearly then that's a passport into you being the next victim. An example of this, and you may have heard of it, is Conti News. And as I say, you'll get details of these issues when we send the sheet out. But the Conti ransomware became a case study due to its increasing use. It was described as a double extortion. Double extortion means stealing and threatening to expose information as well as encrypting it. So both of those, as you will appreciate, have severe business interruption as well as threat of data breach and reputational damage that comes with it. To date, Conti News has 180 victims, mainly in the USA, but has affected businesses all over the world, including Europe, India, Australia, and Japan. The average for the ransomware attack is $100,000 US. And according to Acronis, more than 1,000 companies had data leaked after the ransomware attack in 2020. It's almost certainly to be a whole lot more than that. But that's just one example. It's one example of many of the huge significance of ransomware and the threats that are faced by businesses, entities, and corporations in this day of cyber activity. Well, how does ransomware spread? Mainly through 2 avenues, and both of which, I hope not to scare you too much, but both of which are, particularly at the moment, through everyday usage. Mainly, first of all, through phishing emails, but second and increasingly, remote desktop protocols. Most of you will be working from remote desktop protocols all the time. In a working from home environment, remote desktop protocols have been the savior of many, but they're also the window in through which ransomware demands can spread. A remarkable statistic from the cybersecurity firm ESET is that there has been an increase of 768% between Q1 and Q4 of 2020 with respect to remote working and remote protocol desktop attacks. That just goes to show the extent of the issues that are being faced by those of us who are having to forced to work from home. Phishing has also increased in 2020. 1 in every 4,200 emails is a phishing one. And that's if we just step back from a moment and think about that as a scenario, 1 in every 4,200 emails, when you return from your holidays, you wouldn't be surprised to receive over several hundred emails sometimes. So 1 in every 4,200 emails, particularly if you think about that in respect of a large corporation, is a phishing email. And they account for more than 80% of reported cyber incidents. What do you do when you are subjected to a ransomware attack? Do you pay the ransom? Well, the official view, and it's always wonderful when we have official pronouncements from governments and law enforcement agencies about we don't pay the ransom and you shouldn't do this and you shouldn't do that. Of course you shouldn't, but that's very difficult to do sometimes when your business is going to be interrupted, when there are further issues of business being really potentially destroyed by a ransomware attack. As I say, there's the Office of Foreign Assets Control of the United States has said it's illegal, said that in October 2020 it was illegal to make payments to cyber criminals. And Kerry's going to talk a little bit more about that. There was a recent report just this morning which develops that as a theme. The UK is taking a similar stance. The National Cybersecurity Centre and law enforcement has not encouraged or endorsed ransom demands. But candidly, what happens? Is it easier to pay the ransom, particularly if you have a cyber extortion policy? And so that is of interest because there are some pretty terrifying statistics in respect of those who seek to take on the cyber criminals. In an EY report in 2020, Atlanta in the United States was subject to a ransomware attack in 2018. $51,000 was demanded, 17 million US dollars was needed to rebuild the network. The city of Baltimore didn't pay a $76,000 ransomware demand. It cost $18 million to rebuild the network. So it's easy to say, well, let's just ignore and let's try and do the right thing, but the right thing can be very costly. We will come on later to discuss unforeseen consequences of paying ransomware, such as terrorism financing and breach of the Terrorism Act and things of that nature. But just before I hand over to Shyam, just a quick mention. Lloyd's of London released a report recently with CyberCube and Guy Carpenter on the emerging cyber threat to industrial control systems. They looked at 3 possible scenarios in which hackers could access and take over industrial processes. And it focused on manufacturing, engineering, transportation, and shipping. It also increased also highlighted the increasing risk of the Internet of Things, and you'll be aware of the Internet of Things. Everything appears to have a Bluetooth or other connection. Certainly, fridges have Bluetooth connections, and certainly, as I say, I know for a fact my washing machine has a Bluetooth connection. So whilst I haven't yet had a LinkedIn request from my washing machine to link in because of its attributes to Bluetooth, we all have to recognize that we're all completely joined up in this and we're all in this as potential ransomware victims. So may I hand over now to Shyam, who's going to deal with some cases which deal with the court's approach to these issues we've been discussing.
Thank you. Thank you very much, Dean. And welcome everyone. I'm going to be talking about 3 recent cases from the High Court, which deal with the High Court's approach to issues concerning cryptocurrency theft and fraud. It'll be rather a whistle-stop tour through these cases, but as Dean said at the beginning, you will be getting a digest, so no need to scribble everything down if you don't wish to. So the first case that I'll deal with is the case of AA and Persons Unknown, quite a well-known case now, I'm sure, for many of you. By way of a very brief background, the claimant was the insurer of a victim of a ransomware attack. So this is one of these instances where the sums demanded by the attacker were paid. roughly just over 109 Bitcoin were transferred to the address by the attackers. And following a tracing exercise, some of the Bitcoin were transferred into a fiat currency, but 96 Bitcoin were found to have been transferred to an address that was linked to the Bitfinex crypto asset exchange. Now, at the interim stage, although the claimant applied to the High Court for multiple orders, including a banker's trust order and/or a Norwich Pharmacal order, during the course of the hearing, those matters were adjourned so that the application was narrowed really to a proprietary injunction application. Now, Mr. Justice Bryan, dealing with the case, obviously used the two-stage test, looking at firstly whether there was a serious issue to be tried, and then looking at where the balance of convenience lay. Unsurprisingly, he found that there was a serious issue to be tried, but we're more concerned really with his second finding about the balance of convenience, because he found that it lay firmly in favour of granting relief to the claimants in furtherance of their proprietary rights. And he ruled that the 96 Bitcoin could be dissipated and the insurer has a strong claim to the Bitcoin in question. Further, he ordered some ancillary relief that the defendants do provide information as to the identity of the persons unknown, because he ruled that it was necessary to police the proprietary injunction, and it was appropriate for that information to be provided by way of pre-action disclosure. So what's really the main takeaway from this case? Well, as many of you will know, it was really the first case which defined crypto assets as being property, because they met the four criteria of being definable, identifiable by third parties, capable to assumption by third parties, and also had some degree of permanence. And what was really important about this particular decision was that Mr. Justice Bryan found that crypto assets could be property, even though they might not be a thing in action. Therefore, really extending the definition of what property might be, rather than just simply being either a thing in action or a thing in possession. And notes that he used the term crypto assets, whereas, of course, in the case we were dealing with Bitcoin and cryptocurrency. So we'll wait to see whether, in fact, other forms of crypto assets will also receive the same treatment. Moving on then to a more recent case at the end of 2020, which was the case of Ion Science Limited and persons unknown. This case essentially supported AA and in fact goes a little bit further. Again, by way of very brief background, the claimants were victims of a cryptocurrency ICO fraud, initial coin offering fraud. They were encouraged to invest in a so-called specialist investment firm, Neo Capital, and ended up investing roughly 577,000 in Bitcoin. After, again, a tracing exercise was found that a substantial part of the Bitcoin had been transferred, or their proceeds appear to have ended up in the accounts held by the Binance and Kraken exchanges. Now, as was in the case of AA and persons unknown, the court ordered a proprietary injunction against the first respondent. Mr. Justice Butcher found that there was no evidence the individuals would be able to satisfy a monetary judgment. So again, what are the main takeaways of this case? Well, as I said, it upheld AA and in fact went a step further, because in addition to proprietary injunction, what was also ordered was a worldwide freezing order over the assets of those connected to Neo Capital, and also a banker's trust order. This is important because in AA, that matter was in fact adjourned. So it was uncertain as to whether in these particular situations a banker's trust order could be awarded. Further, the court also found that the lex situs of a crypto asset is the place where the person or company who owns it is domiciled, and that allowed the claimants to serve the first respondent outside the jurisdiction. So a very important case at the end of 2020. And finally, I'm just going to deal briefly with the case of Tomar and Murray. In this particular case, it's contrasted with AA and also Ion because the defendant was known rather than being a person unknown. And in this particular case, the application to continue the ex parte interim injunction was actually refused by the High Court. Although it found that there was a serious issue to be tried, being that of fraud, the judge held that the balance of convenience did not lie with the claimants. And that was essentially because the court found that damages in this particular scenario were an adequate remedy. The claimant's claim, although it was put on the basis of a proprietary tracing claim, was essentially seeking the value of the Bitcoin contained in the CoinDepot account. And therefore damages in the scenario were an adequate remedy, especially considering the defendant was known and he was known to hold significant assets as well. So the main takeaway from this particular case is that it doesn't inevitably follow that just because there's an arguable case for a proprietary remedy, the court will grant a proprietary injunction irrespective of the adequacy of damages and the balance of convenience. And that's all I have to say on those three cases. And I'm going to hand back to Dean for Section 2 and asset recovery.
Sorry, just to add before I move on to Section 2, can you hear me? I hope you can. Yes, good. Just move on to Section 2. What we're seeking to do here, which I hope is of assistance, is bring to your attention the latest movements in cases. As I say, we've produced a digest for you, because these are cases that specialist practitioners such as us are very familiar with and we deal with every day of the week, but they are not necessarily known to others who don't know this area or don't know this area as well. And so it's of great value, we hope and believe, that we bring these to your attention. We want to try and make it not too whistle-stop, but we want to give you the headlines and then try and draw things together as we go through. So that was Section 1, ransomware and payments of that nature. I'm going to just deal now with asset recovery along with Kerry. She's going to help me with this section. And so you've paid your ransomware demand, or you've discovered that you are the victim of fraud. What do you do next? Well, the first step in asset recovery is tracing the funds. The second step is securing the assets. Many of you, if there are commercial litigators as part of our attendance, will know that Norwich Pharmacal orders and Bankers Trust orders are the way in, and we've added for your convenience the Iftsal offshore and Barclays Bank case, which isn't actually strictly a crypto cyber case, but it gives indications, and I shan't go into too much detail now about that, but it gives indications to say of traditional routes in and how you secure, first of all, you trace and secure funds. We say that Bankers Trust orders, worldwide freezing orders, and that kind of injunctive relief are completely, Norwich Pharmacal orders are completely applicable to this area as well. Just because it's cryptocurrency doesn't mean that you can't trace it. And you will have already heard Sham's discussions of AA and ION, which very much make large strides towards that as an aspect. First of all, it's important to say, and a lot of people criticize cryptocurrency. I'm a huge proponent of an advocate of it. But a lot of people criticize it, but actually the evidential audit trail is much easier because transactions appear on the public blockchain. So you can trace the transactions with relative ease because, as many of you will know about the blockchain, it's immutable. That may cause data protection issues, but that's another story. In terms of an evidential trail, transactions which appear on the public blockchain stay on the public blockchain and they're for all to see. And also there are, and growing up much, much more now, and I certainly have had the pleasure and privilege to work with a number of them in my work that I do for companies and entities and governments, to work with experts who can trace into this field. And so don't ignore that as a possibility. Expertise in this area is growing, and it's also important to make sure that you get the right expert for these kind of cases. But you can trace, you can secure. It's really important that you secure crypto assets before they reach an exchange, because the cyber criminals want to get Bitcoin into fiat as quickly as possible, because they know that crypto assets actually can be traced, and fiat is much more difficult to trace, ironically enough, but that's a fact. And so once the crypto assets reach an exchange, it's very, very difficult to trace them. So time is of the essence. What do you do? What are the practical steps? What do we advise? Well, you need to get disclosure orders against the exchanges particularly, and take steps to secure the assets. So as we've been outlining, and as we've said before, disclosure orders and securing asset interim relief is proving to be the most important step in asset recovery. I am on record as saying that it's a very interesting state of affairs that interim relief is becoming in this area much more significant actually than final relief, because you've got to stop the bleeding. So you've got to stop the dissipation, you've got to stop further dissipation, you've got to have the information available for further tracing. And the courts actually have been really forward-looking in terms of how they deal with this area. You've already heard, and I'm not going to go over them again, but they are absolutely crucial cases. Shyam talk about AA Limited. If you haven't heard of that case before, make yourself familiar with it. ION is a really relatively recent and really useful case involving bankers' trust orders and outside jurisdiction service and things of that nature. So you need, if you're going to be dealing with this area or any client with this area, you need a good working knowledge of those. You also will have heard, and this was back in the days before the life changed in November 2019, there was a case called Robertson. Robertson was a case before the UK Joint Task Force in November 2019 recognised the legality, or at least advised the legalities of Bitcoin and smart contracts. Robertson was an asset preservation order and a banker's trust order granted after a fraudulent transfer of 100 Bitcoin. In fact, it was granted in respect of 80 Bitcoin in the end. But that was the beginning of a line which started, went through then the now Master of the Rolls pronouncements in the UK Joint Task Force, through AA, and then on to ION. And so these are really significant jurisprudential areas. And these are areas that the courts have been extremely keen and perfectly happy to recognize. They've recognized secrecy, they've recognized speed, and they've recognized the importance of interim relief. So I'm now going to pass to Kerry, and she's going to talk to you a bit more about some of these cases.
Thanks, Dean. So one of the things that the cases that we've heard about so far have in common, so Robertson, AA and ION, is that the fraudsters and the attacks in those cases were all unknown. Contrast that with the case that Shyam talked about in Toma and Murray, where they were known. And what you can draw out from these cases is that in the persons unknown cases, there will never, I say that strongly, but never be any evidence that the individuals in question will be able to satisfy a monetary judgment. So in that sense, the balance of convenience is going to lie in granting a proprietary injunction, almost as a foregone conclusion, because without one, claimants are going to be left in a position where they have no realistic possibility of recovering any loss that they have suffered as a result of a ransomware attack or a fraud. Contrast that with Toma, where you have a named respondent. Although the proprietary injunction was granted ex parte in first instance, on its return date, knowing that there was a named individual and being able to look into their background and their assets, the balance of convenience didn't lie with continuing the proprietary injunction anymore. And because there's evidence that you can look at in those scenarios, a proprietary injunction is not a foregone conclusion if there is a crypto asset fraud. So that's just something to be aware of and something to think about and to mix when advising clients, that even though you might get a proprietary injunction in the first instance, that may not be continued if you know who the named respondent is later. Drawing on a point that Dean just mentioned about time being of the essence in these and trying to trace and track before things reach exchanges, especially because transfers of crypto assets can take place at the click of a button, Bitcoin was specifically mentioned as a cryptocurrency that can be traced. But you also need to remember that there are some cryptocurrencies that are not so easily traceable. For example, Monero. Monero's privacy is different from any other coins. It uses 3 different privacy technologies. And basically what they do is they hide the sender, the amount, the receiver in the transaction, which means that all transactions on the network are private just as a matter of course. And there is no way to accidentally send a transparent transaction. Most cases that you have heard about and will be in the digest that we send out involve the recovery of Bitcoin and Ethereum, ones that can be traced. But if someone has to pay a ransomware attack or the fraud is conducted in Monero, there may be no way to trace it. Again, something to just be aware of and for people to be aware of and advise clients of, because fraudsters and attackers may become wise to this. Bitcoin and Ethereum are valued for their value, but if more people are going to be eventually taken to court in relation to this, Monero might become the coin of choice. Drawing out a point from the Ion Science case, as Shyam mentioned, this was the first case to consider the lex situs of crypto assets. So that was said to be the place where the person or the company who owns the crypto asset is domiciled. I think that's an incredibly attractive proposition. However, I think it's ever so slightly confusing wording when you consider the technical aspects of crypto assets. In the UK Joint Task Force legal statement in crypto assets, they explained how transfers of crypto assets worked. A new crypto asset with a new title is created on a transfer. So the received crypto asset, be that the one received by a fraudster or a ransomware attacker, is not the same one that the transferor held. And the transferor has no legal proprietary interest in the crypto asset that the fraudster or the attacker holds. Thus, in the technical consideration, the victim of a fraud or a ransomware attack doesn't legally own the crypto assets anymore. The transfer has created a new crypto asset owned by somebody else. And their one is effectively considered spent or cancelled. Add to that it is the private key that effectively determines who owns a crypto asset. The private key says who can control that crypto asset, transfer it, deal with it. And that is what is taken to signify ownership of a crypto asset, unless that private key has been unlawfully obtained. That isn't the case in a ransomware attack or a fraud. The attackers and the fraudsters have set up their own wallets legitimately. They haven't stolen a private key. Their private key is their own. So in terms of who owns it, perhaps better wording could potentially be beneficial owner of a crypto asset. That would apply to the ransomware and the fraud attack, because what is effectively happening is that the attackers and fraudsters are holding it on constructive trust for the victims. However, beneficial ownership isn't necessarily a helpful phrase either. For example, if it is a crypto asset dispute, a legal one, if it's a crypto asset dispute that isn't a fraud, then although it is only usually one person who has a private key, that's not always the case. What if 2 individuals have a private key and they're domiciled in different jurisdictions? How does the lex situs work there? Or, which is another scenario, is if the private key is split between 2 or more people by virtue of a secret sharing algorithm. And they have to act in concert in order to be able to deal with the crypto assets. Again, who owns the crypto asset then? So there are still questions that need to be resolved. And my personal view is that the answers to these require not only a legal understanding, but you have to understand the technology that you're litigating and some of the very detailed nuances that they involve. And that's where expert advice is required. And so on that note, I will hand back to Dean, who is going to start us off with criminal and civil liability, ALM and sanctions.
I always start on a mute, which is always probably the best way for some of you think that it might be the best way to start for me. But anyway, I'm going to speak anyway. So just to pick up on some of those points that Kerry was making at the end there. What is interesting, as far as we are concerned as practitioners in this area, is the increasing association between expert witnesses, expertise of all descriptions, and practical law. because these are areas which they sound very complex. They're not as complex when you get used to dealing with them, but you will have to, if you're presenting cases in court, you are preparing cases for court, you will have to get past the jargon. And I think that's something which we certainly feel is of significance when one is dealing with this area. Once you've got past the jargon, then I'm delighted to say a lot of the principles that we've all been brought up with as lawyers are actually relatively well settled. And we can build, as you probably have already gathered, build on freezing order legislation or rules and precedent. We can build on bankers' trust. We can build on interim injunctions, injunctive relief. So all of these areas are things that we can use in this new age. But getting past the jargon is obviously, in the first instance, a matter of huge significance. Talking of jargon, I'm going to be dealing with a little bit more, something that's a bit more accessible now, which is criminal and civil liability, particularly AML and sanctions. Kerry's going to be dealing with the latter part of that. Criminal liability in this area is of interest. It's fairly obvious that perpetrators of a fraudulent scheme are guilty potentially of fraud offences and money laundering offences. That's pretty obvious. And perpetrators of ransomware attacks and may be guilty of blackmail and money laundering. Kerry is going to talk later on about the case of GH, a Supreme Court decision which said that it would be bad practice for the prosecution to add money laundering counts that are proper public purpose. And so we're really encouraging or discouraging these kind of potential offences to being described in traditional money laundering fashions. But it's not just blackmail, extortion, ransomware attacks, and things of that nature that may be subject to criminal liability. The really, really scary thought about all of this is if you are the victim of a fraud or ransomware attack, you yourself may have criminal liability if you pay the ransomware demand or make the transfer. If you are effectively doing so to further or at least have a reasonable expectation or possibility of another motive. Now I'm going to explain what that means. What is interesting is that paying a ransomware demand is not in and of itself illegal in England and Wales. So, and there's a recent Guardian article, Kieran Martin, the former head of the National Cyber Security Centre, suggests that the ability to claim a ransomware payment under an insurance policy should be banned. There are some in the audience. I'm certainly discussing an interesting project with a solicitor who's in the audience about that very subject. And you may all hear more of that, the fruits of our labour as time goes on. But this whole area of, as I say, we've talked about paying a ransomware. Do you do it? Do you not? It's important if you decide to do so, or your entity or the entity you're advising decides to do so, or if you're advising them yourself, because if you are obviously subject as a regulated person to money laundering and terrorist finance regulations. So in the UK, there are sanctions, obviously, in respect of different types of payments. If you have to very carefully consider whether you are exposing yourself to a sanctions liability by paying the ransom. One of the cases, which is Mamokoshe Mining Limited, that was an interpretation of a sanctions clause under a marine cargo insurance policy, and whether a ransom payment would expose the defendants to breach of US and EU sanctions against Iran. And it was interesting about that because what the court decided in that case, and as I say, it's set out in the digest, is nothing in the sanctions clause which purported to distinguish a claim due to payment being prohibited. Suspensory interpretation could lead to open-ended liability subject to limitation. But if the proceedings were commenced to stop the limitation running, the claim could be stayed during the period when the liabilities to pay is suspended and lifted when sanctions are relaxed. So that was an interesting, probably not fantastically clear and helpful steer, but it did. But certainly I've had people to advise where they, by virtue of doing one thing to get their business running, they're getting themselves into a whole heap of trouble in another. It's important that we note, in passing as we do here, that in October 2020, the Office of Foreign Assets Control in America warned that any ransomware payment is illegal if it is made to a sanctioned entity under its specifically designated nationals list. There are also, and these are for your consideration, there are also significant features that if you are paying a ransomware or ransom demand, you could be in breach of the following sections. I'm going to just outline these to you because time is getting shorter. We do want to take some questions. But Section 15 of the Terrorism Act of 2000 says a person commits an offence if they provide money or other property and knows or has reasonable cause to suspect that it will or may be used for the purposes of terrorism. That may sound as if it's draconian, but if you think about it, why are you paying a ransom? Who are you paying it to? Do you know who you are paying it to? Have you thought about where it might end up? And when you are, as I say, a regulated person advising on these matters, you also have enhanced obligations. So just for your notes, and it's on the digest, Section 15 of the Terrorism Act, Section 17 of the Terrorism Act, Section 17A of the Terrorism Act, all could potentially cap ransom payments. And it is our view that risk ransomware payments and transfers of funds made under fraudulent schemes could come within that definition. So please, again, it's important that you take care when considering this, and I would respectfully say so, take specialist advice. So can I hand over to Kerry to deal with some AML considerations?
Thanks, Dean. So it's sometimes said, similarly to the sanctions and terrorism considerations, that in paying a ransomware demand, the victims of the ransomware attack may have committed an offence under Section 328 of the Proceeds of Crime Act, which is entering into or becoming concerned in an arrangement which they know or suspect facilitates the acquisition, retention, use or control of criminal property. However, in most circumstances, that won't be the case. In the case of R&GH, the Supreme Court considered the constituent elements of an offence under that section, where the arrangements in question began before any criminal property existed. It's a very high-level summary of the facts. An individual established 4 websites that falsely sold insurance to individuals. That individual recruited somebody else who opened 2 bank accounts into which the customers from one of the websites paid money as payment for the non-existent insurance cover. The Supreme Court held that criminal property is property that is already criminal by reason of criminal conduct, distinct from the conduct alleged to constitute the money laundering offence itself. And that the POCA 2002 money laundering offences depended on the commission of another offence yielding proceeds. Therefore, the money paid by the victims was lawful in their hands when they paid it into the accounts. However, its character changed once it was in the accounts, when it became criminal property by reason of it being the proceeds of a fraud. As such, the individual who opened the accounts could be regarded as participating in an arrangement to retain criminal property for the benefit of another. What that means in the case of a ransomware attack is that assuming that the funds or the crypto assets, depending if it's a fiat or a crypto ransom demand, used to pay that demand are not themselves criminal property. So as long as they're clean, there'll be no liability under POCA, as they only become criminal property once the transfer has been completed and they're in the hands of the ransomware attacker. Moving to financial institutions and crypto asset exchanges. Financial institutions, crypto asset exchanges, and custodian wallet providers are required to conduct customer due diligence under the Money Laundering, Terrorist Financing and Transfer of Funds Information on the Payer Regulations 2017 in various circumstances. Those circumstances listed in the legislation mean that if there is any suspicion of money laundering or terrorist financing, individuals should not be able to open an account. However, if they can open an account, the first 2 requirements under the legislation means that there should be KYC and client due diligence on most accounts associated with those attacks. So there is ways to get information on these individuals. These institutions are also required to submit SARs if there are reasonable grounds for knowing or suspecting there's money laundering. And if they don't, there'll be an offence under Section 330 of POCA. Looking across the pond to the US, also on the 1st of October 2020, FinCEN issued an advisory to provide guidance to US individuals and businesses in an effort to combat ransomware scams and attacks. That advisory warned that ransomware payments in any convertible virtual currency may violate AML legislation. And it reiterated that financial institutions must file a SAR in relation to any ransom payments made through them. 2 months later, on the 23rd of December, FinCEN issued a notice of proposed rulemaking regarding certain transactions involving CVCs or digital assets with legal tender status. Under the notice, banks and money services are required to submit reports, keep records, and verify the identity of customers in relation to transactions above certain thresholds involving CVCs and digital assets with legal tender status in wallets not hosted by financial institutions, or whether wallets are hosted by a financial institution in certain jurisdictions. The effectively consultation comment period has been extended, and so we will wait and see if anything changes in relation to that forthcoming regulation. However, based on what the US Treasury Secretary said in an interview earlier this week to CNBC, it is likely that there are going to be stricter regulations on the horizon, at least in the US. So in her response to questions on the record for her Senate confirmation in January, Janet Yellen was fairly measured in her assessment of digital assets. However, in an interview on Monday this week, she warned about the dangers to both investors and the public and stated that she feared that Bitcoin is often used for illicit finance. So it does look like regulation, at least in the US, is definitely on the horizon and is something that is probably going to make its way over here in the not too distant future. But what do you do when you have these considerations when you might be funding terrorism or paying a sanctioned individual? So the watchwords are due diligence. However, there is often the perpetrators are going to be anonymous, and any identification is unlikely to reveal a true identity. And investigation is going to be incredibly time consuming. And when time is of the essence, you don't have that option. So what do you do? Well, saving grace is that in relation to terrorism and sanctions, unless there are clear grounds for knowing or suspecting that the payment would be used for the purposes of terrorism or for the benefit of a designated person, it's unlikely that any payments will attract criminal liability. So you might breathe a sigh of relief on that, because most interactions with unknown fraudsters and unknown ransomware attackers, you're not going to have that knowledge or that suspicion. However, crypto assets, different kettle of fish there. They're becoming a worldwide trading commodity, but they are still considered to be the currency of choice for criminal activities and organizations. You only have to look at what the US Treasury Secretary said earlier this week for that. Therefore, if payments are made or demanded in crypto assets, doesn't it become arguable that there is a reasonable cause to suspect that they may be used for terrorism or are for the benefit of a sanctioned individual? Therefore, the question is going to come down to the public interest test. In most cases, it will not be in the public interest to prosecute the victims of ransomware attacks and frauds for terrorism and sanctioned offences. But that's not always going to be the case. So on a practical note to assist clients, if a company has good offline backup practices, then it should not need to pay a ransomware demand in order to regain access to its systems and its data. If you negate the need to pay the ransomware, you then remove the risk of criminal liability. And what that then means is that assuming good offline backup practices, the only potential liability question for victims of ransomware attacks might be one of civil liability. And on that, I'm going to hand over to Salsa to talk about.
Thank you, Carrie. On civil liability, the case that I'm going to talk about is Lloyd and Google, where there you had a representative action for claim for damages under the Data Protection Act 1998. So it's not GDPR, it's the previous act. And the claimant there was seeking permission to serve out of jurisdiction because Google is in the US. And it is all about the Apple Safari workaround which is a double-click ad cookie placed by Google on websites which are visited by users, but they're not placed by the owner of the website. It's placed by Google instead, in order to bypass, without the consent of users, Apple Safari browser's ad blocking of cookies. And they did that in order to identify, collect information on private data such as web surfing, habits, location, race, ethnicity, social class, political and religious views, sexuality, and also financial circumstances of any user who visited such websites. The main issue here for the Court of Appeal, as Sir Geoffrey Voss said, was the characterization of class members' loss as loss of control or loss of autonomy over their data, which could give rise to a claim for damages. And reversing the first instance court, the Court of Appeal held that despite data not being recognized as property under English law, browser-generated personal data has economic value, and a person's loss of control over such data has a value. So that, despite the wording of Section 13 of the Data Protection Act and of Article 23 of the EU directive that are applicable, not having on its face any statement of recovery for damages for loss of control of data, despite that, the Court of Appeal held that damage should be available because of the common origins and overlapping of protection of privacy and data protection rights, which meant that the remedies available for infringements of these rights, such as damages, should be aligned. And as a result, now under English law, damages may be awarded for breaches of data protection legislation, leading to a loss of control of personal data without proof of distress or any material damage. That's the important bit. And we now understand that several class actions may be stayed pending the outcome of the Supreme Court judgment, which will ratify or not the availability under English law of a representative action in data privacy breach cases. And we must remember that the Court of Appeal in the Morrison case, not the Supreme Court, but before it reached the Supreme Court, the Court of Appeal said that answering the question of, well, there's a floodgates problem here. You may have in future be several hundreds of large number of cases running against ruining target companies. But the Court of Appeal said, well, if that is the case, obtaining insurance such as cyber insurance, they didn't refer to cyber insurance, but cyber insurance is the obvious one here, should be obtained by these companies. And I'll pass it back to Carrie, I think now, please.
Thanks, Elsa. One thing it's important to remember in light of Lloyd and Google and the potential for class actions is that, one, the data breach that's likely to occur is from exfiltrated data from a ransomware attack, but not all personal data breaches will attract civil liability for a failure to have appropriate and technical and organisational measures. The requirement is for appropriate technical organisational measures that ensure the appropriate security of personal data, and there are a range of circumstances to be taken into account to ascertain what is appropriate in various circumstances. But taking an extreme example to illustrate the point that not all personal data breaches will attract civil liability is that no matter how good your technical and organisational measures are, they will never be impenetrable. There is something called 0 days attacks. This is the discovery of new, previously unknown software vulnerability. So you can have the best technically secure system known, have the most stringent organisational measures in place, and therefore have appropriate technical and organisational measures in place. But you can still suffer a ransomware attack and a personal data breach as a result of a 0 day attack. But because you have appropriate technical and organisational measures in place, there won't be civil liability. So what that is effectively is that when there is a personal data breach from a ransomware attack, it requires a nuanced and careful consideration of the measures that are in place. It isn't simply there is this breach, there is liability. It requires very, very careful consideration, a look at what technical measures are in place, and detailed advice. And I guess a further thought from that, it's not just of a liability that you need to consider following a data breach, following a ransomware attack. You've also got regulatory action from the ICO to consider as well, because it's the same set of facts and the ICO might be interested as well. But picking up on something that Celso said in relation to actions being stayed as a result of Lloyd and Google, something that's interesting is that, so the GDPR permits claims for both material and non-material damage. And something I discovered a couple of days ago, actually, whilst looking at doing some research for something, is that loss of control is actually specifically referred to in Recital 85 as a form of damage. On that basis, it means that actions under the old law, so the Data Protection Act 98 might be stayed, but anything under the GDPR, it's the potential that it could actually run. So again, it may be stayed, but based on the actual wording of the GDPR, such class actions might be able to go ahead, irrespective of what the Supreme Court says in Lloyd and Google. And with that, I will hand back to Celso to talk about cyber business interruption losses and cyber insurance claims.
Thank you, Carrie. I will just make 3 points about cyber business interruption claims. The first one is that the development of business interruption wordings in cyber policies is still very immature, is in its infancies. You still have the vast majority of clauses in cyber insurance policies, which base their calculation terms on loss of income rather than the more sophisticated clauses that go into more detail, like the gross profit form or the gross revenue form that are used in property policies. And this reflects the fact that there is very little actuarial evidence that is available to cyber insurers to really broaden the scope of cyber insurance policies, and that is a problem, because the cyber insurance market, there is a demand in the cyber insurance market for broader scope of coverage, for longer indemnity periods, and for more detailed calculation methodology that takes into account very clearly what is a variable cost, what is a fixed cost, and that you have longer than 3 months maximum indemnity period, have 6 months or 12 months, where the indemnity period is based on any effect on the business, as you have in property policies. Instead, in cyber policies, in the vast majority of cyber policies, you have the indemnity period ending as soon as there is the reparation of the breach. So we will have to see what happens in 2021 with the continuing increase of ransomware attacks, whether insurers will be able to provide broader coverage or they will restrict the coverage and increase premium. We will have to see. I will pass it back now to, I think, Ishan.
Thanks very much, Celso. And just picking up on that point about really the nascent nature of cyber insurance policies, that was made very clear in a case that took place in California, which unfortunately we never received judgment on, but nonetheless dealt with some very important issues, because it relates to the failure to comply with positive obligations in a cyber insurance policy. This is the case of Columbia Casualty and Cottage Health System. And in this particular case, Cottage Health System were subject to a proposed class action, which was commenced on behalf of its patients, when it was alleged that 32,500 of their patients' details were disclosed to the public via the internet. And their insurer, Columbia Casualty, initially said that they would fund the $4.125 million class action settlement that had been agreed on behalf of Cottage Health, but then sought declaratory judgment from the district court in California to exclude their liability. And essentially their argument boiled down to an exclusion clause which they sought to rely upon. And that exclusion clause related to a failure to follow minimum required practices. And they alleged that there had been a failure of the insured of Cottage Health to continuously implement the procedures and risk controls identified in its application form when taking out the policy. So as well as a failure to comply with that particular clause, Columbia Casualty also relied upon misrepresentations, but it's really their former argument and their primary argument about the failure to deal with the exclusion, to deal with that particular clause is what was the most interesting aspect of that particular case. Now I say it's unfortunate that we never received a judgment for it, because the judgment would have had a significant impact, because Columbia Casualty didn't rely on any general requirement to take reasonable precautions where the insured must not act recklessly. Instead, they relied on a very broad interpretation of its own exclusion clause. And if Columbia Casualty were successful, they are effectively saying that they can deny liability because the insured failed to carry out continuous checks and risk assessments on its cybersecurity, leading to the breach. And what that does is it begs the question as to, well, what is really the purpose of this insurance policy if it doesn't actually protect the insured for such mistakes? So therefore, in essence, if Columbia Casualty were successful, it would only have been liable for losses caused by an attack that was so sophisticated that it bypassed Cottage Health security when it was being constantly monitored. Now, although there might be scenarios where that happens, as you can see, it significantly minimizes the scenarios in which a claim can be made. And that goes back again to Celso's point about how companies are really crying out for perhaps longer and more detailed indemnity policies, so that they're not falling foul of such wide exclusion clauses. And I wanted to link this particular case to a British example, which isn't related to cyber insurance, but is an important one to deal with, because, again, it deals with the insured's failure to comply with positive obligations under a policy, and really has key advice on how the courts interpret exclusion clauses in insurance policies compared to normal contracts. This is the case of Aspen Insurance UK Limited and Sangster and Ireland Limited. In this particular case, a hotel caught fire shortly after a contractor had carried out some hot works on it, and it resulted in a claim made by the contractor under its liability insurance. Its insurer relied upon a list of precautions that had been listed in the insurance policies, which needed to be carried out by the insured. And the High Court, His Honour Judge Waxman QC, held in favour of the insurer by stating that the exclusion clause was redolent of the typical industry guidance which applies to the undertaking of hot work. He also found that recklessness was not required in order to establish a breach of this particular exclusion, and that's the requirement of recklessness related solely to reasonable precautions clauses, whereas when you have a positive obligation upon a particular party, what he said there was a highly defined and circumscribed set of particular safeguards which have to be put in place. Further, there wasn't any requirement for a causal connection between any breach of the exclusion and the fire that took place. Now, it must be borne in mind that this case was decided prior to the Insurance Act 2015 coming into force, and in particular Section 11 of that act, where causation may be a factor that's taken into consideration by the courts when interpreting a clause which seeks to exclude or limit liability on the part of the insurer. insurer. But what this case really shows is it shows a clear difference between the interpretation of exclusion clauses in insurance policies and ordinary contracts, because the former defines the scope of liability that the insurer is willing to accept, whereas in a normal contract, an exclusion clause provides a way for one party to escape a primary liability. And this was followed in the case of Croden and QBE Insurance, another High Court case. Therefore, the courts will generally interpret an exclusion clause in an insurance policy more favorably for the insurer, as long as it reflects the liability that the insurer is willing to assume at the time that the policy was entered into. Therefore, as a result, clearly defined obligation terms under an insurance policy, which require specific action to be taken by the insured to prevent a risk, might be treated differently from broadly worded reasonable precautions clause exclusions. So it's very important when drafting these sorts of policies to go with a more specific positive obligation as opposed to a generic reasonable precautions exclusion policy or wording. And this type of specifically designed obligation in an insurance policy may in fact reduce the scope of coverage for cyber claims. And on that note, I was going to hand back to Celso.
Thank you, Sham. I'll just finish with this one quick summary of an Indiana Court of Appeal case in the US. Is case of CNG Oil Company of Indiana and Continental Western Insurance of last year. And the important thing to remember here is that there was available in the insurance policy for the policyholder computer virus and hacking coverage extension that wasn't purchased for the by the policyholder. And then there was a ransomware attack in 2017. The system was locked, and the hackers demanded 4 Bitcoin in the amount of $35,000 US, which was paid for by the policyholder, and then they claimed under the computer fraud coverage clause in the commercial crime and fidelity part of its policy, which gave coverage for losses of property resulting directly from the use of any computer to fraudulently cause a transfer of their property. And the policyholder argued that the ransomware attack demand was fraudulently caused because it was a type of unconscionable dealing. Because the hacker had gained access to the insured's computer network by misrepresenting his authority to enter and control those machines as a type of fraud or concealment. But the Court of Appeal of Indiana upheld with the first instance decision, disagreed with the policyholder, and held that the transfer of the Bitcoin was not fraudulently caused by the ransomware demand. It was no different from a burglary or a type of theft. The hijacker or the hacker did not use the computer to fraudulently cause the company to make the transfer of the Bitcoin, and therefore there was no coverage. And the lesson here is that if policyholders want cyber insurance, they should buy cyber insurance. They should not try. They will have great difficulty in trying to make a cyber insurance claim based on a hacking to fall into a liability or computer crime, a fraudulent computer crime policy.
Thank you, Celso. Can I thank everyone for their time? We've got 4 questions in our Q&A, which I'll certainly allocate in a moment. Can I just say, though, that this session, I hope, has indicated and highlighted something which is principally the reason why I got involved in this area of law all those years ago. It's such an incredibly rich area for different aspects of the law. What have we touched on here today? And it's been a real quick skip and canter through all these different areas, but criminal liability, civil liability, interim remedies, bankers' trust orders, insurance policies, ransomware demands. That's why it's so fascinating. That's why everything is, as a cyber lawyer these days, to say that you are a cyber lawyer, you have to have these matters in your armory, this ability to stretch and look across, because there's usually a different aspect or potentially several different aspects of different disciplines involved in any one particular issue that might come across your desk. Can I then deal with the 4 questions? I'm going to allocate these. There's a question from, there's 2 anonymous questions and then a couple from Lisa, who, as I say, I know very well and has kindly joined us all the way from Australia. Let me come back, if I may. I'll seek to deal with certainly one of Lisa's questions. Can I ask this first question, and then I'll assign it. Might the panel have any thoughts on cyber attacks via social media platforms? Are they common? Is ransomware a common form attack on those platforms? I'm going to ask, Shyam, can you help us with that?
Yeah, sure. Well, from my experience, not particularly rare on social media platforms, but however, as we spoke about, I think in the first section, phishing is becoming more and more common, and especially via phishing emails. So certainly if you are getting anonymous messages from people asking you to open links via Instagram, Facebook, Twitter, whatever it might be, certainly would not do that, because it could install some sort of malware on your computer. What we need to understand is that ransomware is almost invited into our particular devices. It's whether we accept that invitation or not, especially if we're working on our own personal devices. And as we know, ransomware is really spreading all the time, and the threat is very much there. So whether you're in your email or on your social media platform, just be very wary if you get an anonymous message. If it looks too good to be true, then it generally is.
Thank you, Shyam. And also just to highlight the fact that what's very important as development this year is the Online Harms Bill, which obviously is going to potentially change the whole landscape of social media and how we interact with social media. Thank you very much, Shyam. I'm going to ask this one, if I may, of you, Celso. Again, anonymous, but could the panel say more about the possible tension, in inverted commas, between facing a ransomware attack and the need to act urgently, and maintaining a cyber insurance cover and the need to follow any insurance stipulations, re-reporting to the police, etc.? How could any tension be resolved or regulated?
This is an incredibly interesting question, because the AML requirements and that the Americans are trying to basically bolster will precisely have this effect of making it very difficult for policyholders to make the payment without falling prey to the possibility of losing coverage. Because one of the things that you normally have in a cyber insurance policy is a wrongful acts exclusion. And by making the payment without going through the proper AML, or refusing to go through the proper AML procedures, that in itself is a wrongful act by the policyholders, and they may lose coverage. So that I think that is precisely the intention of the American authorities. There will be a lot more scope for policyholders to deny coverage in relation to payments of ransomware attacks in the future.
Thank you very much indeed. Kerry, I'm going to ask you this one. Was wondering whether you can confirm ransomware payments should not be insurable, and how can we prevent them from being reimbursed by insurers?
I think this one might actually be better for Celso or Sean regarding insurance.
Not at all. Absolutely.
I'll answer that. This is a fascinating question. At the moment, under English law, on balance, most lawyers think that fines are not payable, are not insurable, and but you have to look at where the fine is being paid. So it depends on the jurisdiction. The vast majority of European jurisdictions, fines will not be insurable. There are issues to do with the vicarious liability that have not been decided yet, and that may be a way which the UK courts could find fines to be insurable, but this hasn't been decided yet, and it's a very complex point.
I think if I might just jump in there as well, I think we also need to remember that AA was conducted by an insurer who had paid the ransom demand, and of course it was found that they were entitled to pursue those sums, and the High Court didn't cast any sort of aspersions on them actually paying. So as things stand, it is certainly insurable, but as Celso said, it's something which definitely is going to be looked into, and will be further judgments in the future, I'm sure.
Thank you very much. I'm going to do my best now to try and, we've got a few more minutes, and try and combine some questions. There's a couple of questions from Professor Lisa Short, and there's also a question about volatility of cryptocurrency. Let me do my best to answer, or at least address, the issues raised in those questions. Lisa is particularly and rightly concerned about the perception of crypto assets with this veneer of crime. Candidly, I feel that a lot of the vested interests like to project that image and make cryptocurrency, particularly some form of handmaiden to crime. Cryptocurrency is here to stay, whatever else may think of this. I'm absolutely convinced of that. The key thing which Lisa is very keen to stress, and I am thoroughly in support of this view, is it's all about education. We've got to make people understand, if we can, that crypto assets are a new way of dealing, a new way of exchanging value, a new way of dealing with business, with transactions. It also makes transactions and currencies much more accessible. Takes it out of the hands of the large bankers and the vested interests, and it makes it more accessible. That's not a utopian thought, because candidly, the large institutions are recognizing the importance of cryptocurrencies. But what we mustn't do is throw the baby out with the bathwater in respect of this, because crypto assets are of huge value in terms of their everyday ability to, for people to partake and find the economy accessible. Decoupling the message and that relationship between criminality and cryptocurrency is, as Lisa quite rightly points out, a product of education. Somebody has asked a question about the volatility of crypto assets and things of that nature. I also, although I'm not a family lawyer, I often share a platform with a family lawyer, and we talk about crypto assets in divorce, which some of you may also have had to deal with in your professional life. The answer to the question about volatility is, first of all, the only way is up at the moment, as I'm sure all of you will know. But second of all, crypto assets, I think, first of all, become less volatile as time goes on, but have regular valuations, as you probably would anyway. But have regular valuations of crypto assets. It's not difficult to get them valued now. And so you can keep on top of the situation of a volatility by virtue of having regular valuations. There's a question here about how would you deal with a small scale theft of, say, 6 Bitcoin. It isn't affordable for many, and the cost of litigation often disproportionate. Absolutely, but what I'm seeing, what I'm doing, and I'm conducting several of these already in my practice, as are members of my chambers, class actions are the answer. There's a lot more opportunity now for people to bind together to say, I've been wronged. I have had situations where I've been wrongly deprived of my property. And as we have, I hope, explained and hopefully set out for you, the courts are actually very willing to be the arbiters and to provide a channel for people to actually to ventilate the wrongs and to seek recovery. Don't forget class actions. Don't forget litigation funding. Don't forget all these new things that are growing up around, and potentially, I don't suggest it's a coincidence at all, but they're growing up around the increase of data stroke cyber related cases. I'm trying to deal with these last few questions, and we'll probably have to call a halt in a moment. It looks like California, by way of the CPRA, is due to come into force in January 23, might end up helping organizations if it imposes hefty burdens on them. Should the UK and EU be going in the same direction? I think the UK and the EU actually have, if I may respectfully say so. I think here we have a situation where with the Online Harms Bill, which I've already mentioned, and the sanctity of personal data, which GDPR has put right at the center of a data subject's rights. I think we are going down the road. I think data protection and the sanctity of data and the recognition of the importance of the quality of data is of huge significance and is being recognized and ought to continue to be recognized throughout the globe. I think probably there, with apologies for keeping you longer than we anticipated. We've tried, I hope, to get through as much as possible. This is the first in a series. The second in the series will feature different members of the 36 commercial team. It will be on the 31st of March at 4 p.m. and the title will be Smart Contracts, Are They as Smart as the People Who Drafted Them? May I wish you all a very good afternoon. Thank you very much for your attendance and appreciate your time. Thank you.